in a probate case, as I understand it, if you're filing a petition to petition a will, at some point a will is filed with the court and made public. If there is no will, they're saying there's no will, then at some point there's the court, there's a code that determines who gets what. But if there's a will, is it true that it would always be filed in a probate if they're trying to probate a will, that it would be made public?
Yeah, so that's the other good and bad news about probate, right? On the one hand, if a will, when a person dies, I'll backtrack. When a person dies in California, California law defaults to the will should be lodged with the court, whether or not a probate ever happens. And that just means a will should be held there for safekeeping. It's not public record. So then if there has to be a probate, then the terms of the will are going to be public record. So on the one hand, that's great for all the people who think they could be heirs and haven't received notice under court requirements. They could at least see the will for themselves. On the flip side, for the decedent or for famous people, everyone gets to read their will. So there's no real privacy, except for a very limited, set of circumstances. Can things be redacted or filed under secrecy rules? But for the most part, once a probate is started, the will is fair game, all the terms. And so that, I guess flushes out kind of a shine of light on the truth of it all, right? So that can be helpful.
If they're petitioning a will, then eventually the terms will come out. Maybe not initially, but at some point you can't petition a will without a will. You can petition intestate without a will, but wills.
And once that petition for probate starts, there are notice requirements that start immediately, where again, all the known beneficiaries under that will and all the heirs under the state law have to receive notice of that probate hearing, and people can come or contest or show up or do whatever they want to do once they get that notice. So once a probate starts, sometimes beneficiaries like a probate because everything's going to happen in open court and they're going to receive notice. And if they don't get the right notice, there can be what they call a defect, and then people can, file objections. And there's just a whole, like a slow moving train that happens once that probate starts, to give people ample opportunity to get more facts or ask questions and figure things out.